personal views and opinions expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with industry leaders around the world with information that businesses need to know now. I have a special guest on the show today. This is Kimberly Gold. She is the Chief Privacy Officer and Senior Associate General Counsel and Executive Director for Privacy and Law at Genentech, which is a biotech company. Welcome.
Thank you. I'm happy to be here today.
Yeah, happy to have you on the show today. We've been connected on LinkedIn for quite some time. I was really interested by, I love your commentary and the things you say. And I think the area of tech and emerging technologies mesh together really well. And I thought you'd be a great person to talk to on the show.
Thank you. And I love talking about this area. I find it very fascinating, exciting. I think also what's interesting about working in this industry is seeing the impact that your work can have on patient care, on new medical treatments, advancing clinical research, and overlaying that with working in privacy, which is super exciting and constantly changing. It's a really fun area to be in.
I agree. I have friends that are in biotech and pharmaceutical companies. And, it's just mind-boggling the issues that you all deal with. Tell me a bit about your journey. How did you get here? How did you get to this place in your career?
Yeah, that's a great question. I think if you ask 10 different privacy professionals how they got into privacy, you'll probably get 10 entirely different answers. For me, I have a legal background, so I did go to law school. I graduated in 2008, and I went to work at a big law firm in 2008, and I started as a corporate attorney, and that wasn't the best time to start as a corporate attorney, given the financial crisis that occurred around that time. And I'd always been interested in healthcare and pharmaceuticals, so my firm had a practice that was focused on healthcare regulatory and transactional issues. And at that time in 2008, I wasn't aware of any firm, at least then, I'm not aware of any firm that had a privacy practice at that time. But I did find healthcare really interesting, and the work was slowing down in the corporate area, but still pretty active in regulated areas like healthcare. So I started to do some work with the healthcare team. I really enjoyed it. I started learning about healthcare regulations. I worked on transactions involving healthcare facilities. And I developed an interest in how technology and healthcare would be intersecting and seeing that would likely be the future of healthcare. No one at my firm was really doing healthcare privacy work, but I started to get involved in industry organizations like the American Health Lawyers Association, and they had a health information technology group that I joined to try to learn more. I started reading up on healthcare information technology, which is now more commonly referred to as digital health, I suppose. And I kind of started to teach myself about how healthcare technology was regulated. I started to teach myself about HIPAA and healthcare privacy. And then there was some work that I found in my firm in the area of at least HIPAA. And so I had an opportunity to get some real world experience doing that work. And then when I moved to another firm that was more deeply involved in the biotech space, but I could do more healthcare technology and healthcare privacy work, I really got deep into healthcare privacy. And then from there expanded into general privacy, and especially working with different companies that are outside of the HIPAA regulated space. So like many pharma and biotech companies don't have direct HIPAA obligations. So I started to learn more about general privacy matters, like consumer protection laws, like the Telephone Consumer Protection Act that applies to text messages. And from there, I was able to do a year-long secondment in Pfizer's global privacy office as part of my work at another firm that I had moved to with a partner that I'd been working with. And so that was wonderful experience that helped prepare me for the role I'm in today. And I just continued to do work with a variety of companies in and out of the health and life sciences space in privacy over the next few years. And then 3 years ago, I was a partner at a law firm, and Genentech was one of my clients. And I was working with them, counseling on the CCPA at the time, and they had this role open. And so then I went to work for Genentech. It just seemed like one of my dream jobs. Something I'd always wanted to do is work in a privacy team in a pharmaceutical company. And that's how I got to where I am today.
I love that story. I love the story that you really sought out those opportunities. You taught yourself. You found that this is the area you really wanted to dig deep in, and you really just carved your own path. And I think that's fascinating.
Yeah, I think there's so many opportunities still for people that are interested in privacy, interested in doing more technology related work if they're lawyers or if they're not lawyers. There are so many opportunities in this field, and there are ways to self educate, and sometimes there's opportunities to find another individual or team in the organization that you're already in that might be doing the work that you'd like to do, and maybe you can work with them. I've had people internally reach out, and it's been great for me to have more individuals and teams that want to work with privacy, and we can partner together. And so it's a really exciting area to be in with a lot of opportunities.
Yeah, I can imagine. I can imagine. I remember I was on a panel once with an attorney from a famous firm. This was around 2016, and we were talking about different implications of privacy laws, around the world. And his thing was that he thought HIPAA covered everything that had to do with health. And I just thought he was crazy. So for people who don't understand, I think a lot of people, ton of people have a misconception that anything health related is covered by HIPAA. But tell me about how not just HIPAA, but how these other laws play into to the life science space.
Sure, it's a huge misconception, even in the healthcare and life sciences space, even by lawmakers. So we've had the opportunity to influence some of the recent lawmaking and to clarify some of the language and how these laws cover or don't cover companies in this space. So HIPAA is absolutely not a law that covers privacy of all healthcare information in the US. It covers a limited scope of healthcare related information in the United States. It was initially passed as well, it's in the name, the Health Insurance Portability and Accountability Act. So it was passed as an insurance portability law. And if you think about it, it really applies to the traditional healthcare provider patient context. And more specifically for providers and for health insurance companies, but providers that bill to insurance companies. So having that nexus there of the billing to insurance is really what brings a provider or health insurance company under the scope of HIPAA. So there's a huge gap between what is covered by HIPAA, which is really, again, information that might be shared or used in a traditional patient provider context, versus all the other healthcare information that's collected and used in the United States. The direct to consumer healthcare apps, for example, that is getting a lot of attention from lawmakers because in most cases, that data is not covered by HIPAA. And that's where the state and federal governments have really tried to fill this gap. And we've ended up with a bit of a patchwork of laws. And so the more recent state privacy laws, I think we're up to at least a dozen by now, have tried to define healthcare information and cover data that's not covered by HIPAA. And they usually carve out data that is already covered by HIPAA, assuming that it's already being regulated by another agency. But both the recent lawmaking, federal enforcement as well, is focused on this health data that's not covered by HIPAA. And lawmakers are really looking at different solutions here. There have been discussions in Congress about expanding HIPAA potentially to cover more health data, but it makes things interesting because there's kind of this layering of the different privacy laws that may or may not apply to health data. And medical research data is also generally subject to clinical trial regulations that require informed consent. And so when these new state laws or proposed federal laws are coming out or being proposed, we're really looking, each one that is proposed, we in the industry are really looking at each one to see what is the impact that this law might have on us and our important medical research activities, for example, where generally the intent seems is that the new lawmaking is intended to fill that gap, though, where HIPAA is not already covering the health data.
Yeah, I think it's a huge confusion. I always tell people HIPAA isn't a privacy law, it's a law about data portability, but it has privacy parts in it. So I think people have.
No, it's true. The HIPAA is the insurance portability law, and then there's privacy and security regulations under that. And so there's also applicability to service providers of organizations that are providers or health insurance companies to capture those vendors or third parties that are handling that data. So there's also obligations on those parties. And I think a lot of software organizations, for example, are often surprised to learn that they're under HIPAA's scope. But there is also this paradigm now of other state and federal laws. There's also state medical privacy laws that are more aligned to HIPAA than the general privacy laws. And then you add on top of that, there's newer state genetic privacy laws. There's newer state biometric privacy laws. And tracking and reviewing each of these and really looking at how these could impact in my instance, I'm looking at medical research and what the impacts might be and whether any changes might need to be made to ensure that there's no negative consequences for medical research while still ensuring that the privacy is maintained of that information, and largely because it's usually regulated under clinical trial regulations already. And sometimes we're explaining that to lawmakers as to what the impact might be and how the language could be adjusted while still maintaining the privacy of individuals' information.
Yeah, I think that's true. There's a regulation or law around breach of security, I'm sure you're familiar with. And this covers people who do health apps. A lot of people haven't heard of this, but really it's trying to fill that gap where companies that aren't subject to HIPAA, but also collect medical information or health information, they're subject to this breach of security rule. Is basically saying if you have a breach, you have to take these steps, even though HIPAA does not apply to you. What are your thoughts about that law?
Yeah, that's, again, I think another area where the federal regulators are trying to fill the gap where HIPAA doesn't cover that. Yeah, the health breach notification rule it's an old rule, and it wasn't really applied very much until pretty recently. And now the FTC is leveraging that rule in enforcement actions against companies that are handling healthcare data that's not subject to HIPAA. Like I believe GoodRx was one of the early enforcement actions that applied the health breach notification rule. And there are also discussions and comments gathered at the federal level on how to potentially not only revise HIPAA, but also potentially to revise the health breach notification rule. And this is, of course, on top of the state breach notification laws that exist in every single state and say something a little bit differently in each state. And some of those do explicitly cover health information, but most do not.
I would love for you to explain to people what PHI is, personal health information. Sometimes people get it confused with PII or personal data, but if you could explain that, that'd be great.
Yeah, sure. I mean, PHI is officially a term of art under HIPAA that stands for protected health information. And so legally, it's a term that is used to describe health information that's personally identifiable, that is subject to HIPAA, that falls under that scope, that's either collected, processed, maintained by one of those organizations that is already subject to HIPAA. But it's also used pretty colloquially, I think, to describe personally identifiable health information in other contexts. And sometimes that the information is thrown around, but I think the distinction is that personally identifiable information is broader and can be any information that can be used to identify an individual, but personal health information, protected health information is really a subset of that. That is that health information that could be used to identify a person that relates to health treatment or healthcare services that that person might be receiving, or their diagnosis, for example, is another example where if it can be tied back to that individual with their name, for example, then it's probably within that scope of personal or protected health information.
Very good. Thank you. Tell me, how is AI impacting your work in privacy?
I think AI is impacting everyone's work in privacy right now. And as companies are finding new ways to use artificial intelligence, and in many instances, there are privacy considerations, such as when personal information is being used to train models. And sometimes there are no privacy issues if there is no personal information being used. What a lot of people don't realize in these discussions around regulating AI is there is some AI regulation already existing in privacy laws as we have them now, particularly in certain state laws where the use of automated decision making is regulated by some of the state laws. And we're seeing more laws focused on the use of AI in hiring and employment decisions.
I think that what AI does, it heightens some of the privacy issues or privacy concerns, especially as you said, personally identifiable information can be sucked up into those models. So I think that it's definitely a balancing act for companies. So I've seen companies do it three ways. So they either try to shut the gates and like, okay, we're not going to use AI, which I don't think is realistic. They go full force ahead without really thinking about the risk because they're really excited about the innovation. And then I think more people fall in that middle space where they're like, well, let's take a look and see what it makes sense to use AI for and make sure that we are understanding the risk and we're educating people about how and when they should use AI. What are your thoughts?
Right. It's completely unrealistic to say that an organization can never use AI at all. I agree with you. It's more about educating on the responsible and ethical uses of AI and how data can and cannot be used. And a lot of times, because privacy is so data heavy, when a company is looking to use AI or using AI, privacy is often one of the first calls. And sometimes companies are kind of grappling with, where should AI really sit within the organization? Because it is broader than privacy, but it is also becomes a privacy issue when personal data is involved. And so a lot of privacy organizations within companies are deeply involved in AI initiatives and guiding the business on how to use data and using AI responsibly and in compliance with laws. So I think it's more about helping the business and working together with the business to ensure it's used responsibly rather than shutting it down. And that there are also many beneficial uses potentially, particularly in the medical space, for the use of AI. So we often find that there's more of a partnership between the privacy team and the business team than what you might normally think of as legal counsel. I enjoy that part of this work. I enjoy that part of being in privacy is really partnering with the business, finding innovative solutions, helping them find ways to move forward in a compliant fashion that protects people's privacy.
There are so many different groups that work within business and corporations. I think as a privacy person, because privacy is such a horizontal issue, you have to work with the entire organization from top to bottom, but then also you have to find a way to have champions in different groups. So how do you go about getting buy-in from different groups or developing champions within different groups for privacy?
Yeah, there's a lot of education, I would say almost every day, on privacy. And this is an emerging area too. And it is getting more attention internally and externally as there's new uses of data, potential uses of AI, and new legislation. A lot of organizations have a concept of privacy champions, as you mentioned. We have a privacy network internally that has been developed, and we have, similar to champions, we call them liaisons throughout different functions in the organization, representing functions throughout the business, IT, other parts of legal and compliance, and many other areas of the organization. And together making up this larger network that the privacy office leads. And we're giving guidance, for example, on implementation of new privacy requirements. And then we rely and partner with the liaisons throughout that network to help us implement those new requirements throughout the business and help us monitor. And also, it's a two-way conversation. So those liaisons can help educate their teams, and they can also bring new matters or issues that could have privacy implications back up to us and keep us educated on things that might be happening in the business or areas where they need additional guidance, legal advice, or things like contract terms or additional training. So it really is this collaborative relationship. And I think it's necessary to have that because privacy does touch on every single part of the organization. I can't think of an area that it doesn't touch upon. And so it's so important to have those partnerships. We also work very closely with the IT security functions, as you could imagine, as new products or initiatives or programs are being built or changing. It's so necessary and important. And I'm grateful for those relationships and those supporters throughout the organization who can help us implement privacy, and also, particularly as it's changing, as the laws are changing, the requirements are changing, to help keep things up to date and implement new requirements.
Yeah. What do you think is unique about privacy in the biotech space that people may not understand?
I think it's unique in how it's regulated, and it is very complicated. And it's not as simple as biotech being regulated by one healthcare privacy law. So a lot of healthcare organizations, they're mainly in the US regulated by, let's say, HIPAA, for example, and in which case most of their data is exempt from the newer state laws. For biotech, since most of our data is not regulated by HIPAA, then it becomes this complex web of other legal requirements. And we're looking at consumer protection laws at the federal and state level, the comprehensive privacy laws like CCPA, CPRA, Virginia, the other handful or dozen that now exist. Then genetic privacy laws, clinical trial regulations are also an area that it's not necessarily thought of, I think, by many privacy professionals. And then adding to that are clinical trial regulations that are relevant in this space that are not necessarily within the body of the general state privacy laws, for example, that are coming into play. They've been around for a long time, like FDA regulations, HHS regulations, good clinical practices. And these standards require informed consent and set out those standards for collecting data in a clinical trial. And so there's just so many different areas of the organization that have different types of data that might be regulated differently. So in the clinical trial space, there's those clinical trial regulations. If there's a marketing program, there could be consumer protection regulations that apply depending on the activities and the types of data. Like email marketing, you might have to look at can spam. Text message marketing might have to look at TCPA. And when you're collecting data on websites, there's state privacy laws and general consumer protection laws. And then there's employee data that's collected. So I think what's interesting is that there's different regulations and different requirements and different parts of the organization, depending on what's being collected and how it's being used. So it makes things very interesting and exciting. I think every day can be a little bit different. And it's important to have a really deep and broad understanding of privacy laws, of clinical trial regulation, of consumer protection laws, because there might be different requirements in many different areas depending on what's actually happening.
Yeah. I think 2024 is going to be a very interesting year in privacy. At this point, I think there are at least 12 privacy laws that are going to go into effect. In 2024, there are parts of laws that are going into enforcement that are already in effect 2024. And I think for people who have already thought that we needed like a federal privacy law, I think they're going to be pulling their hair out in 2024. What are your thoughts?
I get asked this question all the time, whether I think there will be a federal privacy law. I think most privacy professionals agree that we need one and that it's not sustainable to continue on this path of having new state laws popping up in different states, and then there's new proposed federal regulation and then enforcement at the federal level. And I think most would agree that we would be better served by one comprehensive law that would apply across the board. I think we're still going to have some challenges like we had with ADPPA. There were a lot of issues around preemption, and there really needs to be state alignment with the federal government in order to move anything forward. I think now we have Washington with very stringent health data privacy requirements that will be coming into force, and Washington has to be in alignment with the federal government as well. So while I'd like to see a federal privacy law, it's so important that the federal law would preempt all of the other states. And I think that's where we're going to see some challenges. So I'm not super optimistic that we're going to see a federal privacy law in the next year. But what's interesting is that this is something I predicted a while ago, but I think what is almost emerging is a comprehensive standard across the US, because now we have, I think Delaware would be the 13th state privacy law. So now that we have over a dozen state privacy laws, most organizations, I believe, are implementing a comprehensive US privacy program that covers all of those privacy laws, all of the different state requirements in one program, rather than going state by state, which would be just untenable. And especially as more and more state laws are coming out. So almost in effect, we're seeing a comprehensive standard emerging where organizations are looking at those common threads across the state laws and implementing programs to cover all of those state requirements. So I would be interested in seeing if the federal government would be looking at what are those common threads that we already have at the state level, and how could we establish a federal standard that is consistent with what organizations are already implementing to apply those state law requirements.
I think that's true. There are many organizations that I've seen, especially when CCPA came out, they had just made a decision as a business that they were going to apply CCPA type consumer privacy rights to people in all states because it was easier for them to do it that way, as opposed to say, okay, this state is different, this state is different. So I think you're right. I think we are seeing businesses say, okay, this is crazy. Like, this is really hard. Let's find those common threads. Let's try to get something as strong as possible within the business so that we're not lurching from one law to the next. But then, of course, you have to take into consideration any ways that those laws diverge. I think that's still a reason why people are going to pull their hair out about these laws.
That's right. It almost becomes a gap assessment every time there's a new state privacy law. Is the first step is a gap assessment between that law and everything else that's already been signed into law, and so that you can look quickly to say, well, what's different? What might I need to change about our privacy program to deal with this new state requirement? Because in large part, they're looking very similar. They're all kind of following this Virginia model. And except for, again, like Washington, the My Health, My Data Act is getting a lot of attention in the healthcare and life sciences industry, and organizations are trying to figure out how to grapple with those new requirements that are different from the general state privacy requirements. And then layering on top of that, so many organizations are not just US, so many organizations are international, are collecting data or using data from other jurisdictions. So, in implementing a global privacy program that also applies these differing US requirements, what organizations are generally doing is applying privacy principles across the board and having principles-based privacy programs and looking at what are the privacy principles that are interwoven into all of these laws. Things like transparency, making sure that you're clear with the individuals about what data is collected and used, and having that data used and collected consistent with what you've told the individual, or data minimization, only using the least amount that you need for a given purpose. Those principles are largely interwoven into all of these privacy laws. And so most global privacy programs are largely taking a principles-based approach that aligns to those common principles.
Washington State has the My Health, My Data Act or law, and I would love your point of view on that law. I know that people have heard about it, but I think that someone like you in biotech is probably closer to that. So maybe you can explain what it is and what it does.
Sure. The My Health, My Data Act is a Washington law that was signed in the spring of 2023, and it goes into effect in 2024. And specific to health data in the state of Washington. And it was passed in reaction to the recent Dobbs decision, and really intended to protect health privacy of Washington residents, especially for reproductive health care. So there are provisions that are also intended to fill that gap that we've touched upon a little bit, in how health data may or may not be regulated. And there's provisions that apply to geolocation data, for example, which could identify what type of reproductive care someone might be obtaining. And I think it's going to be interesting to see if other states follow Washington and adopt more comprehensive privacy laws that are focused specifically on health data. It's something that those in the industry are definitely watching to see what happens with Washington and how it impacts the organization's practices, as well as what states or even the federal government might do in response to the Washington law. I recently saw that there's a Senate member, Cassidy, that was soliciting feedback on HIPAA and whether and to what extent HIPAA should be expanded. And I think some of that is also in reaction to laws like Washington's law that get passed that really show that there's an interest in protecting individuals' health privacy to a greater extent than what we have right now, which is that mix of different privacy laws in the states and federal government. So it'll be interesting to see what happens as a result, and whether the other laws are following Washington's lead.
Yeah, it's really interesting. So I know that the FTC has really ratcheted up their enforcement, especially around location data. So, I think it wasn't surprising that a state like Washington did a bill like this, but maybe we'll see more of that in the future.
Yeah, and FTC has been focusing a lot on health data as well. There's been quite a few enforcement actions recently. Health data is one of the more sensitive categories of information. And so the FTC has been focusing on health data as one of its areas of enforcement, as well as we're seeing a lot of activity around online tracking technologies, and which may or may not share health data with social media sites. And HHS has put out some information about healthcare providers' use of that technology and giving them some guidance on when it may or may not be subject to HIPAA and what types of things to consider in using those technologies. There's also a lot of litigation activity in that space. applying, similar to the FTC health breach notification rule, but in the area of applying an old law to new technology, and the Video Privacy Protection Act that's from the Blockbuster video age, intended to protect video rental data, is now being used by plaintiffs' firms to bring litigation and arbitration actions against companies that are using the metapixel. So there's all different areas that more and more enforcement and lawmaking is happening. And I do see a focus on the use and sharing of more sensitive data categories like health data.
Yeah, I agree. I agree. So if it were the world, according to you, Kim, and we did everything that you said, what would be your wish for privacy anywhere in the world, whether it be law, human behavior, or technology?
My wish is for a federal privacy law in the US. This is probably an answer that many people give you, but I would love to see an alignment across the United States on the regulation of individuals' information and bringing together the different considerations of these existing privacy laws and coming together to best protect individuals' information through a comprehensive federal privacy law would be my wish for the future.
It's a good wish. It's a good wish. I'm sure many other people will wish the same thing in 2024 when all these other laws kick in.
I think that's right. And yes, it's complex for organizations to track and follow and comply with all of these different privacy laws. But ultimately, it's about protection of individuals' information, and finding one single comprehensive approach across the US, I think, would also benefit individuals and how their information is protected.
I agree completely. I agree. Well, thank you so much for being on the show. This was fantastic. I love to talk to people in your area because it is very complex, and it's more complex than people know. And, it's only getting more complex. So I think you're doing the right thing and moving in the right direction.
Thank you. I also love talking about privacy and really enjoyed speaking with you today. So thank you for having me.
Oh, that's so sweet. That was my pleasure. My pleasure. Well, hopefully we'll have chances to collaborate in the future.
Yeah, I think so. We'll probably come across each other at all of the different privacy industry organizations and events.
Yeah, totally. Totally. Well, thank you so much and have a good day.
Thank you. You too.
Yeah, bye-bye.
Bye.